Minister, in closing.
Thank you, Madam Speaker, and I want to thank the members for their contributions in this debate and their support of this bill. I also want to thank the Legislative Scrutiny Committee for its careful consideration of the bill and its report that I received on the 29th of April 2025. I am pleased to see that the committee has recommended that the bill be passed with some proposed amendments, and I will discuss those recommendations and the amendments further in my summing up. Madam Speaker, I'm very proud to have introduced and now to oversee the passing of this bill through the Legislative Assembly. These amendments will introduce crucial changes in the Northern Territory to hold DV offenders to account, to protect DV victims and provide additional funding and support to DV victims, specifically to victims of crime and also generally. Under Labor, the Northern Territory became the jurisdiction with the highest rates of domestic violence in Australia, with intimate partner homicide rates 7 times higher than the national average. Our government made a commitment before the 2024 election to reduce crime and address community safety, and this bill is a step towards achieving that commitment with respect to domestic and family violence. Domestic violence offending remains high in the Territory. It is a matter of grave concern, particularly for vulnerable members of our community. Therefore, as part of the development of this important legislation, our government listened to the community and victims who were crying out for strong government action in light of women being bashed and killed in the Territory by their partners. And as part of the consultation process, our government sent this bill to the Legislative Scrutiny Committee, where we received extensive submissions. And again, we thank everyone for taking the time to provide their input into the bill. All recommendations are broadly supported by our government, subject to some minor variations. Recommendation 1 of the Legislative Scrutiny Committee is that the bill be passed with the amendments proposed. Recommendation 2 proposes that the approved financial assistance form, lodgement process and any associated policy or guidance materials be reviewed to ensure the process is easy to navigate, flexible, simple and accessible for those who face English and digital literacy barriers or digital accessibility challenges. This recommendation will be addressed operationally by the Crimes Victims Services Unit of the Attorney-General's Department. It is intended that any new application form lodgement process will be included in a community of practice project, which the Crimes Victims Services Unit intends to commence in 2025, which will encourage and support collaborative support for victims of violent crimes. Recommendation 3 proposes Section 24 be amended to provide that the Director must not appoint a person to be an assessor for the Victims Financial Assistance Scheme unless the person has the skills, qualifications, training and experience to properly perform the role. Our government supports this recommendation, excluding the reference to qualifications, and consultation with the Crimes Victims Services Unit confirmed that there is no requirement for the word qualifications because there is no formal requirement for qualifications as the role of the assessor in the future. This has not watered down the training requirements, which is the crux of the committee's recommendation, and I will be proposing those requirements are included by way of Assembly amendment. The final recommendation, which is recommendation 4 of the committee, is that the explanatory statement be amended to clarify the policy intent of the amendments to Section 24 and explain fully the extent of the proposed amendments to Section 24. We are further amending Section 24 by Assembly amendment. Madam Speaker, I will be proposing an amendment to correct a drafting error in the commencement clause, which is clause 2. The Assembly amendment will amend the incorrect reference to Section 21 to correctly read Section 14. Section 14 amends Section 61 of the Victims of Crime Assistance Act 2006 with respect to the imposition of the Victims of Crime levy. The amendment changes monetary amounts to revenue units. It is appropriate this amendment commence on the 1st of July 2025, the start of the financial year. The Assembly amendment will ensure the correct section, which is Section 14, commences on the 1st of July 2025 rather than on assent like the rest of the bill. Secondly, the Legislative Scrutiny Committee recommended the bill be passed with a further amendment to Section 24 of the Victims of Crime Assistance Act 2006, which is aimed at ensuring that assessors are appropriately trained to perform their role. I will be proposing an amendment of that nature during the bill's consideration and detail stage. The new provision will include a requirement that the Director may, in writing, appoint a person to be an assessor for the financial assistance scheme if the Director is satisfied that the person has the appropriate skills, training and experience to perform the functions of an assessor. The committee also recommended the explanatory statement be amended to clarify the policy intent of the amendments to Section 24 and to explain the full extent of the proposed amendments. It is common practice for the explanatory statement to mirror the bill, which was originally introduced into the Legislative Assembly, and ordinarily, if a clause is amended by an Assembly amendment, the explanatory statement is not updated. Madam Speaker, the amendments proposed in Clause 13 amend Section 24 of the Victims of Crime Assistance Act 2006. Section 24 provides for the appointment of assessors for the purpose of conducting assessments of applications for financial assistance. Currently, assessors must be appointed by the Minister and must be a lawyer. Currently, the Director can also be appointed as an assessor. Clause 13 is primarily aimed at removing the requirement that a victim of crime assessor be a lawyer. The new provision specifies the person who are considered assessors for the financial assistance scheme, and these will still include the Director of Crimes Victim Special Units, the Victim Crimes Services Unit, a person authorised under the Law Officers Act 1978 to act in the name of the Solicitor for the Northern Territory generally, which means the lawyers within the Office of the Solicitor for the Northern Territory, and a person appointed by the Director of the Crimes Victims Services Unit under subsection 2. Subsection 2, as amended by the Assembly Amendment, will allow the Director of the Crimes Victims Services Unit to appoint a person in writing to be an assessor for the financial assistance scheme if the Director is satisfied that the person has the appropriate skills and training and experience to perform the functions of an assessor. The requirement that assessors are lawyers has been removed. The requirement that additional assessors are appointed by the Minister has also been removed. The Director may now appoint assessors, provided they are satisfied the person has the skills, training and experience to perform the role. These amendments in Section 24 of the Victims of Crime Assistance Act 2006 will broaden the scope of available assessors, allowing flexibility within the Crimes Victims Services Unit to address variations in the numbers of claims at any one time. The crux of the Legislative Scrutiny Committee's recommendation is that the assessors satisfy necessary training requirements, and this is addressed by the Assembly Amendment. Madam Speaker, domestic and family violence grew out of control under 8 years of Labor, who removed mandatory sentencing for domestic violence offences and put the rights of victims beneath the rights of offenders. The reintroduction of mandatory sentencing is a clear indication of our government and our commitment to addressing domestic and family violence. Madam Speaker, examples of how these new mandatory sentencing laws will work in practice are as follows. Where an offender has a DVO placed on them and they then proceed to text the victim, call the victim and turn up at the victim's house either in a single day or over the course of a few days or weeks, then those multiple breaches of the DVO will be brought before the court and the offender will be sentenced to actual imprisonment, so they understand the court takes these orders seriously and that the offender gets the message. In this example, that offender now has a history of breaching their DVO. So if they breach their DVO again, they are captured by mandatory sentencing and they are once again required to serve actual imprisonment and will face even longer in prison. Finally, if an offender breaches their DVO and threatens to harm the victim or actually causes harm to the victim, then they are facing a maximum prison sentence of 5 years and once again actual imprisonment. With the passing of these new laws, the Northern Territory will have the strongest and robust mandatory sentencing domestic and family violence laws in the nation. These new laws will ensure offenders are put behind bars, and when the offender is behind bars, Madam Speaker, the victim is safe. Madam Speaker, Some of the criticism from the opposition is that mandatory sentencing is not an evidence-based approach to deterring DV offending, that mandatory sentencing does not work, and that deterrence of crime through punishment does not work. However, data suggests otherwise. In a study produced by the Western Australian Law Reform Commission, which looked at the effectiveness of the Western Australian mandatory sentencing laws for certain property crimes, data shows a 40% reduction in car theft and a 30% decrease in break-ins. Clearly, that is working. In addition, a study produced by Dr. Ben Vollard in the Netherlands entitled Preventing Crime Through Selective Incapacitation tracked criminal laws implemented by the Netherlands, allowing for significantly longer prison sentences, up to 10 times the usual duration for offenders with a history of multiple offences. The study found that cities that applied the law experienced a 25% reduction in theft rates, with the most intensive applications leading up to a 40% decrease. This is evidence that punishing offenders does lead to a decrease in crime. Our government understands that DV is often shaped by many complex factors like trauma, substance abuse, poverty, and emotional and mental health issues. What our mandatory sentencing laws mean is that if an offender breaches a DVO, they will receive a term of actual imprisonment. That sentence of imprisonment can include an intensive community corrections order, which can mandate that an offender undertakes behavioural programs and rehabilitation. This is why we have given the court the tools to send high-risk and repeat offenders to prison, where they can engage in programs when inside and once out as part of their sentence. They will continue to be required to engage in programs by the court and intensively case managed to reduce risk of offending and risk to the victim. With this approach, we have balanced consequences with rehabilitation. This is in addition to the funding allocation to the Circuit Breaker program, which includes $6.6 million ongoing, which will tackle these root causes, as well as our $12.9 million boost to boost school attendances through the School Attendance Officer program, and our $3 million allocated for the school-based police program. Madam Speaker, I've heard members today talk about payback and the risk of offenders reoffending on release, and I refute the idea that we cannot hold offenders accountable for their actions because they may reoffend. The truth is they're already reoffending. What the opposition is saying is don't hold violent offenders accountable because that will make them even angrier for the inconvenience of having to be held accountable and go to prison. This is not a criticism that I take seriously. We will not be dictated to by these violent offenders and keep these vulnerable women in a culture of silence through violence. This type of criticism was sadly put forward by many, and to them I say that they may need to reevaluate their outlook on this issue, because recommending that we don't punish offenders because the offenders might then hurt their victims more is allowing victims to be held at ransom by violent thugs, and we will not allow that to happen. If the offender is behind bars, the victim cannot be hurt and has the opportunity to get a better situation and to seek help and support. And Madam Speaker, the logic is simple. If the offender is behind bars, the victim is safe. And our increased support of victim services and support will ensure victims are safe even when the offender is released.
Opposition Leader, please be quiet.
Madam Speaker, our government is ensuring that the court has the tools to send high-risk and repeat DV offenders to prison, but that's just one part. As a government, we've invested more in offender programs in our short time in government than Labor did over 8 years. Through corrections, we have focused on offender rehabilitation and engagement through the Family Violence Program. When in custody, and we have seen 103 completions of this program, which is more than when Labor was in government. In addition, we have seen much greater engagement in the RAGE program, a 6-month-long intensive domestic family violence program with 41 completions versus 12 when Labor were in government over the same time. Madam Speaker, what we know also keeps victims safe is when they are armed with more knowledge about their offender, not less knowledge. And this is why our bill will expand the type of information that the Victims Register can receive from the Crime Victims Service Unit. Before our amendment, the information made available to the Victims Register was only in relation to an offender who is sentenced to a term of imprisonment. Our amendment to the Act expands its application and removes the reference to a term of imprisonment, ensuring it will also apply to sentences which do not result in an imprisonment, and importantly, will also apply to breaches of orders. What this means is that when an offender breaches their parole, suspended sentence, which might include breaching of electronic monitoring condition, then that information can be shared with the victim, who can then take additional precautions and is not left in the dark. Madam Speaker, we're also making offenders pay by increasing the levy for guilty offenders up to 40% to bolster funds for victim services. These amendments will also cover victims of non-domestic violence related crimes. Madam Speaker, I want to thank all the members for their responses and contributions in this debate. I also want to thank all of those first responders, especially the police, the ambulance officers like the first aid officers, and all the hard-working people in the domestic and family violence space. These are the people on the front line of this issue, and they deserve our acknowledgement. I also want to thank the Attorney General's Department for all of the work on this important bill. Madam Speaker, I might just respond to a couple of the comments made by some of the members in the House during this debate. And I do want to remind those who opposed mandatory sentencing, and in particular those in the Labor opposition, and the opposition leaders specifically, who smugly pretend that they hold all the truth as to what works and what doesn't. Remember, you had 8 years. You applied your approach to this issue and you left the territory with the highest rates of domestic violence in Australia. An intimate partner homicide rates 7 times higher than the national average, and yet you still pretend that you have all the answers, which is absolutely ridiculous. Unfortunately, it seems that Labor and the Leader of the Opposition remain committed to protecting ideology more than lives, which is why we're in this mess. The Leader of the Opposition has no credibility on this argument, and she can pretend she has the evidence. However, the evidence we have is that under her government, under her watch, DV exploded in the Northern Territory. Madam Speaker, I thank the member for 𝙍𝙬𝙼𝙍, who I note rightly pointed out that for years Labor spoke in soft words and used soft hands when dealing with crime and domestic violence. As the member for 𝙍𝙬𝙼𝙍 stated, police data shows that over the last decade there was a 117% increase in domestic violence-related calls. That is a failure of Labor, who clearly lost control of the issue. Madam Speaker, Labor love to talk in vague terms as their evidence-based approach, but offer nothing. He also pointed out the Pareto principle of criminal offenders, and evidence which shows that the percentage of high-risk criminal offenders in a community is generally very small, typically estimated to be between 1% and 5% of the population. So he said by targeting this small percentage of repeat high-risk DV offenders, which our laws are designed to do, our mandatory sentencing laws will naturally reduce crime and provide a much-needed circuit breaker for the victim to get to a safer position and away from the offender. Madam Speaker, the member for 𝙍𝙬𝙼𝙍 stated that mandatory sentencing does not work because the offender may only be sent to prison for 7 days or 14 days, and that is not enough time to engage with programs. And that's why we don't have a minimum of 7 days or 14 days, because this isn't the case, and we have provided the courts the tools to hold these offenders accountable. And it also includes an increase of the maximum sentence of 5 years for the most serious DV breaches. And with our investment in corrections and behaviour programs, that's what will ensure that we get the offenders the treatment that they require. Madam Speaker, the member for Nightcliff made an impassioned address to the chamber, and I am sorry to hear how she was a victim of domestic violence. And that is awful, absolutely. But I didn't appreciate her just assuming that nobody else in this chamber has ever experienced what she has experienced or knows what it's like to go through. I think that's just a making an assumption and a judgment call. She doesn't know the members intimately in this chamber, so she doesn't actually know who's been through what. So I think she should hold those kind of remarks to herself. Madam Speaker, the member for 𝙍𝙀𝙇𝙀𝙑𝘼𝙔𝙍𝙏 peacekeepers, and I enjoyed his contribution because I've been out to the Community Justice Centre, and I know they also talked about how the member for Johnston used to do some work out there as well. And I think those kind of programs are great, and they are actually federally funded. And I believe that there is some allocation of money going towards the Community Justice Centre. So I think that they do some great work, and I think we should keep fighting for that funding, which will help those types of communities be able to interact with each other to prevent.
Can you pause, please, Minister? Opposition Leader, please refrain from talking, chatting. You're in the chamber. This is a professional context. We don't want to hear this ongoing commentary from the sideline. Minister, you've got the call.
Thank you, Madam Speaker, because this morning when the Leader of the Opposition had her contributions, we all sat very respectfully listening to that contribution, and so it is quite rude, and I thank you for pulling it up. Madam Speaker, I also thank members for 𝙍𝙀𝙇𝙬𝙍𝙎, for Blaine, member for Catherine, who's also our Education Minister. I think she spoke at length about some of the shelters that are in her community and how well they work and how she's looking forward to seeing them get some extra support. I mean, the Minister for Prevention of Domestic Violence continually talks about all of the work that she's been doing in that prevention space, and I believe she even mentioned the statistics in mandatory sentencing, the changes of the statistics when Labor removed mandatory sentencing. It went from a number and then they removed it, and it increased exponentially, which just goes to show that this whole argument that mandatory sentencing doesn't work is preposterous. So, Madam Speaker, I also heard some of the members say, and apologies for not remembering exactly which ones they were, but the mandatory sentencing won't keep the community safe. And I reject that outright. And as I've said many times, the logic is simple. If the offender is in prison, the offender cannot hurt the victim. And the victim has time to get into a better position and out of harm's way. Madam Speaker, it's obvious that in relation to mandatory sentencing, we will agree to disagree. And you can't, like the Labor opposition and some of the crossbenchers come at a position of ideology, but I approach the position as saving lives, Madam Speaker. So with that said, I now move for the bill to be read a third time.